Good morning, students. Students, good morning.
Morning, ma'am.
Morning, ma'am.
Morning. I hope everybody can hear me. JC, can you hear me?
I'm trying to send it, but then the network here is slow.
Okay, please mute yourself. Mute yourself except for JC. JC, can you hear me? Okay, JC has left. Students, thank you for joining today's session. Please, as always, let us remain, let's mute ourselves. Let us remain mute ourselves. Only unmute yourself if you want to say something, or if you have a question, or if you are answering a question. Today, we are going to talk about the patrimonial consequences of a divorce, specifically focusing on settlement agreement and pension interest. So let's start with settlement agreement. What do you understand by settlement agreement? Anybody, when we talk about a settlement agreement, what is that? Putali, your hands is up. Putali? Okay, Maria?
Yes,
Maria? Okay, who's speaking now?
Morning. Hi, ma'am.
Okay, just wait, Maria. Just wait, Maria, and then we'll come to you. Butali, you can talk.
Yes, madam. My understanding of settlement agreement, it's the agreement between the two parties. In this case, I mean, the husband and the wife, I mean, where they agree on what to be done in relation to their dissolution of the dissolution of the union.
Okay, thank you for that. Maria?
Morning, ma'am. What I understand about settlement agreements is an agreement drawn between the spouses, detailing how they're going to share their assets and liabilities on the dissolution of their marriage.
Okay, thank you, Nkosana.
Yes, my understanding, it's an accepted practice in South Africa, where the spouses would regulate their assets, be it that mainly it's in a community of property and also in the out of community property when they are accruals. So that it's my understanding.
Okay, thank you for that, students. A settlement agreement. Thank you for that, student. A settlement agreement is an agreement entered into by divorcing spouses, whereby they agree on how they are going to share or divide the matrimonial estate, and it also contains clauses regarding parental rights and responsibilities. What you must understand about a settlement agreement is spouses who choose to enter into a settlement agreement are not bound to follow the matrimonial contract or the matrimonial regime that they entered into. For example, spouses who are married in community of property. In the settlement agreement, they can agree that each party must keep their own assets and each party must keep their own pension funds. Those who are married out of community of property with complete separation of assets, they too, in a settlement agreement, can agree that we are going to share everything equally. The most important aspect of a settlement agreement is both parties must understand the terms and conditions of the settlement agreement. They must voluntarily enter into the settlement agreement. Nobody must be forced to enter into a settlement agreement. The settlement agreement, it is only binding on the parties and third parties once it has been made an order of court. If spouses, for example, they are married in community of property and they enter into if spouses are married in community of property and they enter into a settlement agreement between the two of them, whereby they agree on how they're going to divide their joint estate, but when the divorce is finalized, the divorce decree says division of the joint estate. The settlement agreement that they entered into privately will not be enforceable on both of them and also on third parties. So it is important to note that for a settlement agreement to be binding, it must be made an order of court. So my question to you guys, to you students, is what terms do you think can be part of a settlement agreement, and what terms do you think that the court may reject? For example, let's say in the settlement agreement, the parties agree that, okay, you as the ex-wife, you are going to get primary residence of the minor children, and you are going to retain the house. But in the settlement agreement, then there's another clause which says you can retain the house on the condition that you never date any man, and no friends or family members are allowed to come into that house. So my question to you is, do you think the court can approve this clause where there is this condition that the ex-wife can retain the house, but only on the condition that none of her friends, none of her family members, and her future lovers or her future spouses are not allowed to enter or to live in that house? Anyone? Anyone, students? Let's hear JC. JC?
Yeah, morning, ma'am. Morning, everyone. Ma'am, the court won't be bound by any provision made in a settlement agreement, especially if such an agreement is deemed to be contra bonus mores or contrary to the law. In the case of Kotze versus Kotze, the court held that a condition made by the parents that the children must attend a certain church or go to a certain was deemed to be a infraction on the rights of freedom of religion of the children. So in that instance, the court won't be bound by such provisions, ma'am.
Okay, thank you, JC. Nkosana?
Yes, ma'am. I want to agree with Jason in that regard, on the basis that the court are very strictly in terms of venturing in issues of that nature. Particularly, they are regarded as contra bonus mores. So courts, they are very well in entering such a jurisdiction, because even on that case which he has highlighted, Kutse is one of the typical example that the case the court refused. But I think the court does have the discretion in terms of advising the both parties as to what is it that it has to happen, and also to give them the opportunity to go and engage, maybe bring up about their disputes. So if they are not happy with the outcome of the court, then the court might advise to say that they must go to the civil, they must embark with that issue in a civil court. So that is my understanding.
Okay, thank you, Nkosana. Khadija? Khadija?
Good morning, ma'am. I will agree with JC, because that is contra bonus mores, and it would be morally wrong to isolate a person from their family and their friends. So that condition would definitely not be upheld by the court to deny her access to her family.
Okay, thank you, student. You are correct. This is one of the clauses that the court will not approve based on the fact that it is contra bonus mores. Now, I want to ask about debt. Let's say the divorcing spouses were married in community of property, and in the settlement agreement, they agree that each party is going to be liable for debts that are registered in their own names. We know that when you are married in community of property, you become jointly liable for all the debts in the joint estate. Now, do you think the court will approve the clause where the parties agree that each party will be liable for debts that are registered in their own names? Listen, Nkosana, is your hand up again? Nkosana?
Yes, ma'am.
Yes.
I think the court, ma'am, is having the powers to make a declaration in that regard, because I'm taking reference to, I think the case was Brandner versus Brandner. So where the court made a declaration order, it upheld that. Ma'am, I'm trying to check.
Okay.
Yes, I'm trying to check, but because I've read this one, but I think the court is having the powers in that regard, even if it's a settlement to impose a declaration order if they are not in agreement. It will depend from the nature of the agreement between the spouses.
Okay, thank you for that. Khadija? Khadija?
Yes, in that regard, there are only certain debts that one spouse will be liable for. They cannot be liable for all the debts incurred by the other spouse.
Okay. JC? JC? Okay, JC.
Yeah, ma'am,
Okay.
I'm here. Thank you, ma'am. Ma'am, I'm not sure if I'm on the right path, but I think that the parties can change their marital system. In other words, when they are married in community of property, it will be acceptable if they would change the conditions or of such a system, if the court deems it fit.
Okay, thank you, Jesse. You are correct, but that belongs to the subject of alteration of the marriage contract, the marriage regime. Now we are talking about settlements agreement and what the parties can agree in a settlement agreement during the process of a divorce. When it comes to debts, spouses are allowed to agree that each party will be liable for debts in their own name, but practically third parties, for example, the banks, are not bound by the agreement between the parties. Let's say, for example, here's a creditor which launches and which sues for recovery of a debt from, let's say, from their wife, and the wife does not have the means to pay the debt. The third party, the creditor, is allowed to go and sue the other spouse, the husband, even if the settlement agreement, they agree that everybody will be liable for their own debt. The creditor can sue the third party because the husband, because the husband was part of the joint estate. And once the husband has paid the money to the creditors, the husband can now go and claim back the money from the ex-wife, because in terms of the settlement agreement, he did not have a legal obligation to pay on behalf of the wife, but that is an agreement between the two of them. The reason why this is so is because in the settlement agreement, the parties which enter into that agreement is just the wife and the husband, the wife and the husband in the civil marriage. Because it's just the two of them, the settlement agreement is not automatically binding on the third parties. Let me give another example, which is a common example that, or a common situation that happens during the process of divorce. In most instances, spouses who are married usually have a joint bond. So when they divorce and in the settlement agreement, let's say they agree that the husband will retain the house and the husband will be solely liable for the bond payment. The bank or the financial institution which is financing the bond is not bound to say, okay, because the settlement agreement, it was agreed that the husband will retain the house, then the husband is the one who has to be liable for the bond payment. The creditors, the bank, can still and say, when you entered into this joint bond, the agreement was you, the wife, will be liable, or the money will be deducted from your bank account. The bank can continue to do that because they are not bound by the that provision which says the husband must retain the house and must be solely liable for the bank. The creditor's interest needs to be protected. If the husband who has retained the house does not, if the husband who has retained the house through a settlement agreement does not qualify on his own, does not qualify and is unable to afford the bond on his own, the ex-wife will not be removed from that financial obligation. So it is important to note that in a settlement agreement, although the spouses can agree on anything as long as it is not against public policy and then it is not against contra bonos mores, there are circumstances whereby third parties will not be bound by the provisions of the settlement agreement, especially if their interests are not taken care of. I hope that you understand. Does anybody have any question on settlement agreement? Nkosana?
Yes, ma'am. As I was reading, I've noted that on this subject of settlement, there are some different views, particularly on the issue of the declaring order of deeds of settlement. So I'm taking credence on the case of Brandner versus Brandner, where the court held that a deed of settlement binding simply means that the court is issuing a declaratory order that the agreement is binding as between the parties and does not amount in incorporating it into the divorce order. However, at Tsehlo versus Tsehlo and the other one, the case, those court held a different view. So I need your clarity, ma'am, because I was a bit unclear with those cases, particularly that they are contracting views. So I needed the clarity on your side.
Okay, they are contracting views, but in most instances, the settlement agreements are made an order of court, because if they are not made an order of court, they don't become binding and their spouses don't necessarily have to follow their provisions. Again, an example of spouses who are married in community of property. If the settlement agreement is not made an order of court, a spouse can say, okay, because the settlement agreement was not made an order of court, the provisions or some of the rules that form part and parcel of being married in community of property are still applicable.
Okay, no, I understand. So basically, ma'am, what's happening there is that even if there can be no declaratory order by the court, but there are general rules that are applicable for the dissolution of the estates, particularly which are going to be encompass on the basis that the marriage it's in community of property or out of community of property. That's what we are basically saying.
Yes.
Oh, okay.
Yes,
Thank
okay.
you,
Buinelo?
Oh, hello, ma'am.
Hello, Buinelo.
I just needed to know, I don't know if I understood correctly. But then my question is, does this mean that if people are married in community of property and then they do not have a is it a general rule that people who are married in community of property 50% they would share their assets in the middle, even though they do not have a settlement agreement? Or do they have to have a settlement agreement? Does it have to be stated in the settlement agreement how it's going to happen? Or if the settlement agreement is not in place, would it then be a general rule that it's 50%?
Okay, thank you for that. If the spouses don't have a settlement agreement, the other options which are available is the court can order division of the joint estate, equal division of the joint estate, or they can order forfeiture of benefits. We're going to talk about forfeiture of benefits in our next session. So to answer your questions, spouses who are married in community of property are in a joint estate where they share everything, both assets and liabilities, 50-50. A settlement agreement is a document where spouses decide themselves that, okay, this is how we are going to divide our matrimonial estate. And in the settlement agreement, they will decide themselves if they are going to share everything 50-50. If they want to share everything 50-50, they can still record that in the settlement agreement. If they want to share certain assets or certain liabilities, but retain others to be solely liable or to solely benefit from them, that they are allowed, and that must be recorded in the settlement agreement. When spouses have a settlement agreement, their divorce is usually known as an uncontested divorce, because everything has been agreed upon and it has been reduced into the settlement agreement. If there is no settlement agreement, and if none of the spouses brought a claim for forfeiture of benefits, then the court will order equal division of the joint estate. So when the court orders equal division of the joint estate, and once that the court has ordered that, now the parties needs to decide, how are we going to divide this joint estate? Are we going to sit down and, let's say, for example, are we going to go to our matrimonial home and then go per room and decide, okay, you take this fridge, I take the microwave, or I do this? Or are we going to get a liquidator and ask the liquidator to sell everything, pay off the debt, and after paying off the debt, and then we are going to share whatever is left, any proceed that is left? So the reason why settlement agreement are encouraged, and why in most court these days the presiding officers are insisting that the spouses must have a settlement agreement, because it is the settlement agreement is a detailed document where spouses will specifically state, even if they agree that we are going to share everything equally, they are going to be specific with exactly what is it that you are going to get and what is it that the other one is going to get. Remember that in most of the household assets, even if the court says share them 50-50, it becomes impossible. Let's take Let's take a fridge, and let's say the parties only had one fridge. if the court says, okay, you're going to share that fridge 50-50, so the parties need to agree because they cannot cut that fridge into half. So are they going to sell it and share the money? Or if not, then if they agree that, okay, you can take the fridge and then in turn, I will take what is it? The microwave or the washing machine and whatever asset that they have. So the settlement agreement, when it comes to household asset, as an example, there's usually a table whereby it will say the plaintiff will get this asset, the defendant will get this asset. When it comes to the debt, it usually records that, okay, the matrimonial debt consists of all these following debt, and then the plaintiff will be liable for this, the other one will be liable for that. So I hope that you understand. You don't have to have it, but if you have a court order that just say division of the joint estate, that also it is not problematic. But if you don't agree to sell everything, you will have no choice but to enter into a settlement agreement, post the divorce, and then bring a court application to make that settlement agreement an order of court. I hope you understand.
Yes, no, I am answered, ma'am. Just
Okay.
one last quick question. I want to know if say for example, one of the parties have a house, for instance, but only only his name is on the title deed. Maybe they got the house before they got married or something like that. And now, now that they are divorcing and the other party is not on the title deed, but then they are married in community of property, that house, even if the other party's name does not appear on the title deed, will also be part of the shared assets, right?
Yes. Remember, when you get married in community of property, you will automatically share and own whatever you had before and whatever you acquire during the marriage. So if you enter into a marriage and you already have a house registered in your name only, your spouse will automatically own 50% of that house, and you don't have to hire a conveyancer to have your spouse's name also registered on the title deed. 50% ownership will automatically go to him by virtue of being married to you in community of property.
No, thank you very much. It's very clear to me, ma'am. Thanks.
Okay, thank you. Who was speaking? Nolitando?
Hi, how are you, ma'am?
Fine, and you?
I'm okay. So, ma'am, can I please ask something? Is it possible that we get with a spouse, they get married in community of property, which automatically means they have to share 50% of everything, right? And then they sign a settlement agreement, which actually states that maybe the husband passes away and the wife can't inherit, maybe, let's say, a house, because they signed the settlement agreement. Is it possible like that?
No, it's not possible. A settlement agreement is entered into during the process of a divorce. And in the settlement agreement, you cannot put in clauses that are applicable during death, or clauses which are supposed to be part of your will. For example, in a settlement agreement, you cannot, this used to be allowed before, but now the courts no longer want it. When spouses will say, we agree that our child will retain this house. So that clause, when you say our child will retain this house, your child is not part of your marriage. So the court now say those clauses should be removed from the settlement agreement, and they should be incorporated into your will. So if there's any clause that, let's say for example, any clause that you want it to be applicable when death occurs, unfortunately, it cannot form part of a settlement agreement. But what spouses can agree on is maybe one party retain, let's say, a certain asset 100%, and they can maybe verbally agree that you must do a will, and in the will give the house to our child or give the house to our children. But the unfortunate part of it is you cannot force anybody, firstly, to have a will, and then secondly, if they have the will, the terms or what to do with their estate. So to answer your question, a settlement agreement cannot contain clauses which are supposed to form part of your will, or which are supposed to be applicable only when death occurs.
Oh, okay. Thank you so much.
Okay, thank you. Anybody else who has a question on settlement agreement before we move into pension interest? Okay, Jabulile? 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 Jabulile, can you hear me?
Yes, ma'am, I can hear you. Can you hear me?
Okay. Yes, I can hear you.
Yes, ma'am. My question is, during the divorce settlement, if both parties are married in community of property, and it so happens that the other one gets disabled and they get a payout from their work, does the amount that the other party is going to get, is it going to be included in the divorce settlement, or does it only belong to the party that is disabled?
It depends. It depends on where the money comes from, what was the reason for the disability. Let's say, for example, they got disabled at work or while in a motor accident. Those monies do not form part of the joint estate. So in a settlement agreement, the parties can agree that we are going to share that money. So if the owner of the money voluntarily agrees that I want my spouse to have 50% of this money, then it is allowed. So when you are married to an income of property, you must remember that there are certain assets which are deemed to be separate assets and they don't form part of the joint estate. So if in a settlement agreement it is agreed that whatever forms a part of our separate asset, we are going to retain them as our separate asset, that is allowed. But if you take your separate assets or your own money, which does not form part of the joint estate, and you agree that it must be shared equally, that is allowed as well.
Okay, ma'am. Thank you.
Okay, thank you. Okay, now we are going to move to pension interest. So my question is, do you understand? Can any one of you just tell us what is a pension interest? When you talk about a pension interest, what are we talking about, and how is a pension interest different from pension benefit? What is a pension interest and what is a pension benefit? Anyone? Students?
Ma'am,
Okay,
pension,
Jesse.
yeah, thank you, ma'am. A pension interest, ma'am, is deemed to be part of a spouse's assets on divorce for purposes of determining the patrimonial benefit to which the spouse is entitled. This is different to a pension benefit. A pension benefit is an asset that doesn't form part of the person's estate because the right to claim is only vests on the date as provided for by the fund when this guy goes on retirement, when he goes on pension, or he resigns from the pension fund, ma'am.
Okay, thank you. Maria?
Ma'am, I think pension interest is the amount when the member of the pension is still a member of that pension fund. then it becomes pension benefit when he or she has withdrawn from the pension and has acquired the funds, then it becomes pension benefits.
Okay,
when it's still a member, it is pension interest. Then when he's withdrawn, it's pension benefit. I think so.
Yeah. Okay, thank you so much. Let's hear Tando. Tando Ngobo. Tando?
Hi, am I audible?
Yes, we can hear you now.
Okay, I'd like to give it a try. I think it's the total amount I'm referring to. I'm gonna answer the interest part. It's the total amount of the party's contribution to the actual pension fund up to the date of the divorce.
Okay, thank you, Tando. A pension interest is an interest that has not yet accrued to the member at the time of divorce. Basically, is when you are still employed and you are undergoing a divorce, that pension, because you are undergoing a divorce but you are still employed, you have not been retrenched, you have not resigned, you have not retired, your spouse will have a share, a 50% share if they're married in community of property, or if they are married out of community of property with the accrual or subject to the accrual system. And in terms of the antinatural contract, they have a right to claim your pension interest. So they can claim it during that process. And a pension benefit is your a pension that you have already withdrawn and the money is already in your account. So the difference between the two is the one that is yours, but as an employee, you do not have access to it. But a pension benefit is the one that the monies are already with you. So my next question, before I talk about my next question, I want to talk about a pension interest and settlement agreement. Spouses who want to share in each other's pension interest, irrespective of their matrimonial regime, they need to specifically state it in the settlement agreement that, for example, the defendant is entitled to 50% of the plaintiff's pension interest. If spouses enter into a settlement agreement and they do not specifically include a clause for sharing pension interest, the non-member spouse will not be able to automatically get a share if they bring in a withdrawal application with their pension administrators. This is because the law requires that when spouses want to share in each other's pension benefits, in a settlement agreement or in a court order, the pension must be specifically requested and it must be worded in a specific manner, which word must include the words pension interest. If the clause just say we are going to share pension benefit, that again, it is not going to be a binding on the pension administrators, because the law requires that the words pension interest must be specifically stated in the settlement agreement or in the divorce order. But if there is a pension benefit and the monies are already with the spouse, let's say, for example, they are with the plaintiff, in the settlement agreement, the parties can agree that the defendant will get 50% of the pension benefit which are in the plaintiff's bank account. before I take you, Nkosana and Maria, to understand a student, to understand the difference, especially when it comes to spouses having to claim a share of the non-member spouse having to claim 50% share of their spouse's pension interest. Maria?
Ma'am, I have a question. Say during the divorce proceedings, the defendant claims her pension or his pension, so that the plaintiff will not be able to apply for it or to get the 50% or the pension interest. Is there any remedy that the plaintiff can have if the defendant claimed the pension during the divorce proceedings?
Okay, that one is going to depend on two things. Ne? The first thing is, let's say in the settlement agreement, the defendant has signed and has agreed that the plaintiff can will have 50% of the 50% of his pension interest and does not disclose that he had already withdrawn his pension. So if there is a clause like that, the defendant will be still liable. The pension administrators will no longer be liable to make any payments because the fund will no longer be in existence, and then the plaintiff will have to bring a claim against the defendant. And then the second option is when the defendant withdraws before the process of divorce and discloses that I am no longer a member of the fund. The plaintiff can, during the process of a divorce, then bring a claim for either the bank account of the defendant to be frozen so that he does not use or she does not use the pension monies that have been defendant. Or the other option is the parties can agree that, okay, because you have already withdrawn and used 50% of what was supposed to come to me, you can either forfeit your share from my 50% or we can have an adjustment in the joint estate where, for example, if the plaintiff was supposed to get, let's say, 500,000 from the pension fund, and then the parties' matrimonial estate, they were supposed to get 600,000 or 700,000 after a sharing, after dividing their joint estate. The plaintiff can say, you are going to forfeit maybe 50% of this house in return that I do not bring a court application for you to pay me back 50% of what I was supposed to get. So that is how the non-member spouse can claim and get an opportunity to get back the pension money that was, I would say, fraudulently withdrawn. When the parties are undergoing a divorce, it is against the law for anyone, especially those who are married in community of property or those who are married out of community of property with the accrual system. It is against the law for the parties to dispose of their assets or to dispose of their pension, because that by disposing, they are prejudicing the spouse who may have a claim over the pension or any other asset during the divorce.
Oh, okay. So even if he moves it to, say, to a different account or move it to somebody else other than his own bank account, the other spouse can have a claim.
Yes, they can have it, especially if it was done during the process of divorce.
Okay.
Okay, thank you. Can you hear from Lorraine? Lorraine? Lorraine?
Can you hear me?
Okay, we can hear you now.
Yes, I just want to follow up from the question that the last speaker just asked about if someone can transfer the money to a certain account. Does it mean that during the process, the attorneys have access to check all the transaction that the defendant has gone through in order to check whether there was an amount that I was able to move? Does it mean that now people, when we are going through divorce, the attorney are able to go through my accounts and all that?
Okay, the attorneys are not able to go through your account, but there is a process called discovery. The discovery process is when both parties disclose their financial information, their financial record. Let's say, for example, you disclose your bank statement. When you transfer money, when you do electronic transfer, there will always be a track record for that. So that is how that is how attorneys are able to track and to see that, okay, monies have been transferred from this account or to another account. The other option of tracking this is by hiring forensic investigators. So forensic investigators will be able to track any monies that has been fraudulently withdrawn and hidden somewhere. But as an attorney yourself, you will not have access to the other party's bank account. The other option that is available is bringing an interdict application. Interdict application is when you request the court, let's say, to order a certain bank, let's say NetBank, to order NetBank to disclose financial information of the other spouse. So information will be traced via discovery, either by forensic investigators, or if you successfully get an interdict order, and then the bank discloses the financial information.
Okay, thank you. Before I go, I just want again to make sure that I understand this part. The patient benefit, it means that this is the money that by the time when we are doing the process of the divorce or the settlement, I have that money within my bank account, right?
Yeah, it's a withdrawal benefit.
No longer waiting. You are no longer waiting.
Okay, can you hear me now? Student?
Yes, I can hear you.
Okay. A pension benefit is a withdrawal benefit, is a benefit that has already been withdrawn and has already accrued to the member. And a pension interest is the one that has not yet accrued to the member. In other words, it is still with Alexander Forbes or one of those pension administrators. You have not withdrawn it.
So are you saying that when now my pension benefits are out and we are married in community of property, during the settlement agreement, am I allowed to specify that because this is my personal, my pension benefit, I don't want the defendant to get, or the fact that we were married in community of property, it gives the defendant a right to also have the 50% of that pension benefit? Okay.
I need you to note this case Ndaba versus Ndaba. I'm just looking for the new citation. Ndaba versus Ndaba. This is a Supreme Court SCA judgment where they held that it is where they held that spouses who are married in community of property, the pension interest, it is deemed to form part of the spouse's assets when determining the patrimonial benefits during the divorce. So when you are married in community of property, you only own 50% of your pension interest. The other spouse automatically owns 50%. So if you have withdrawn it and it is in your bank account, your spouse still has is still an owner of 50% of it. So in the settlement agreement, you cannot agree. You can agree by saying, okay, everybody will keep their own pension. Let's say yours is already in your bank account, but your spouse has not resigned, and his is still the pension interest. So you can agree that everybody will keep whatever is theirs, but you cannot say, because I've already withdrawn it, it is in my bank account, I do not want to give you 50% share of it. Ndaba versus Ndaba, Supreme Court of Appeal judgment tells us that you only own 50% of it, even though you were just the employee working, and you are the only one who acquired that pension interest.
Thank you so much. It was clear.
Thank
Thanks.
you. Alfred? 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 Okay, Alfred cannot hear you. Can we hear Lorraine? Lorraine?
Sorry, ma'am, I didn't put my hand down.
Okay, thank you. Alfred?
Hello?
Yes, is it Alfred?
Yes, can you hear me?
Yes, we can hear you.
Yes, how are you?
We're okay, Alfred.
That's good. My question is, does it matter how long that I've been working? Let's say maybe for instance, like I have a year working and the other spouse is like 10 years working. Will I still be having that 50% on her pension, and will she be having my 50% on my year working?
Yes, when you are married in community of property, whatever you had before you entered into the marriage and whatever you acquired during the marriage, you are going to share, including pension. So the only time where spouses get to keep the share of the pension which they had before they entered into the marriage is when in a settlement agreement and in the pension clause, they specifically state that they are going to share 50% of their pension interest that was acquired by both of them after they got married. If you don't specifically state that the pension interest that must be shared must be the one that was acquired from the date the parties got married, the pension administrators are going to make payment from whatever it is available in the pension up until the date of divorce, because the pension clause would be saying the defendant is entitled to 50% of the pension interest of the plaintiff. Do you understand?
I didn't get that part when you say if he didn't stipulate it on the agreement.
The pension clause is like this. It says the defendant is entitled to 50% of the pension interest of the plaintiff in the government employees pension fund membership number 123. So if the clause is like this, the government pension fund GEPF is going to pay from the day the plaintiff became a member up until the day of the court order. But if the clause further says the plaintiff, the defendant is entitled to a 50% share from the time the parties got married, and then they specify the date of marriage, GPF is going to pay from the date of marriage until the date of divorce. So to determine whether the spouse is going to get from the date of marriage or from the date when the member spouse became the member is gonna depend on what was agreed upon in the settlement agreement.
Okay, now it's clear. It's clear now. Yes, now it's clear. So the other question, ma'am, is during that divorce order, it doesn't matter who was at fault or whatever. It stays like that on the sections. That is 50.
No, it does not matter. Remember, we have a no-fault divorce system, but we'll talk about it next week, in our next session when we talk about forfeiture of benefits. In a settlement agreement, spouses can agree on anything as long as they voluntarily enter into that settlement agreement, and the settlement agreement is not against public policy. The settlement agreement will be approved by the court.
Okay, noted.
Thank you. Nandipa? Nandipa?
Hi, ma'am. Can you hear me?
Yes, I can hear you.
Okay, thank you. I just want to know, in a matter of a couple married in community of property, then one, while they're still married, resigns, take the whole pension to a financial institution like the Alexandra folks and them. And while the money is there, the spouse is getting like a monthly interest, I don't know what money, or that money is only for the owner. I don't know if I'm clear.
Okay, you are clear? Okay, this is how I'm going to answer it. Ne? We have a pension funds, we have retirement annuity fund, and we have pension preservation fund or a provident preservation fund. All of this, the non-member spouse still has a right to claim 50%. So if a spouse is married and while during marriage, they resign and withdraw, but they don't use the money. They put it in a preservation fund, and then every month they get monthly allowance. The non-member spouse is entitled to 50% of the capital amount that is still there, and also a share of the monthly amount that they're going to get. But the monthly amount, you're only going to get a certain percentage, because once the divorce has been granted, you as the non-member spouse, you are not going to continue getting the monthly amount, but you are going to get the lump sum from the 50% that has been saved, or that is with Alexander Forbes. Do you understand?
Thank you so much. It's clear. Thank you so much.
Okay, thank you. Buinelo?
Oh, thank you, ma'am. I just need to know that, say for instance, the member of the pension fund withdraws the money and then maybe uses the money. And then I want to know if there's an expiry date, like maybe if these people are going through a separation, they don't stay together, and the other one, the non-member, is not aware that the person has already withdrawn the money. And when they learn after, and the person has already used up the pension fund, is there an expiry time, or you cannot claim anything, like maybe after 2 years or ntho?
Okay, no, there is no expiry date, but during the process of divorce, if let's say they have been separated and the spouse who has withdrawn and used his money to claim 50% of the other spouse's pension interest, the other spouse has an option of bringing a claim for forfeiture of benefits, requesting, asking the court that the other spouse forfeit 50% of the pension benefit or the pension interest, because the member spouse did not get 50% from their from the other spouse's pension. We are going to talk about forfeiture next in our next session. So that question is more relevant for forfeiture when we discuss under what circumstances can a spouse be forfeited from getting a certain benefit, including pension benefits. Okay, thank you. Nkosana? Nkosana?
Thank you, ma'am. Yes, thank you, ma'am. Ma'am, I must indicate this topic is very interesting, particularly on this issue of the pension interest, because really we are seeing a norm of certain shenanigans which are happening, particularly where the spouses are married, and then when things are no longer rosy, then you would see some money being taken from the other spouse's account to private accounts. So I just wanted, ma'am, to check with you, because I think you've answered that issue, that there are remedies which are there to ensure that they guard the interest of the other spouse in relation to that. But one thing that I wanted to check, ma'am, because there are cases there which I think the views of the court are different in relation to the issue of the pension interest. So I think you've said there is a case that you gave in Ndaba versus Ndaba. So that is the standard case now that it's applicable within our case law, that a 50% portion, it must go to the other. But ma'am, at the very same time, what I want to understand, if the both spouses are working together, they are working together, and then in their settlement agreement, they elect that no, upon when we get divorced, they've specified that we're not one must take the other 50, and then the other one will take the other 50. So there is no issues when it comes to that, ma'am. I just want to check, because I know we can agree that 50-50, but now if we are both working and then we decide to divorce now, and then what happens? Because the other one was working and then the other one is working, and then how do we treat that situation, ma'am?
Okay, in a settlement agreement, if they agree that they're going to share in each other's pension fund, that is allowed. If they agree that one spouse will get a 50% share, but the other spouse is not going to get a share, that is allowed. If one party was working where there were no pension benefits, or they did not have pension funds, but the other spouse at their work, there's pension fund, the non-member spouse has a right to say, I want 50% of the pension. With Ndaba, I want to emphasize that the court was basically saying, when you are married in community of property, you automatically have 50% share of your spouse pension fund, pension interest. So you do not have to specifically request that in a settlement agreement, or when you are divorced, can I also, in addition on all these other assets, can I in addition also get 50% of that of your pension? That is yours automatically by being married in community of property. So the spouses there, what they need to negotiate on is, okay, are you going to keep will each party keep their own pension? But no spouse married in community of property can say you do not have a right to get 50% of my pension fund, unless if they bring in a claim for forfeiture of benefits.
My last question would be to say, ma'am, we are married in we are married in community of property, and then I seem to understand you to say, when you were explaining that despite the fact that we are married in community of property, there should be a settlement agreement that the both spouses agree that certain assets are going to be dissolved in this fashion. So let us assume now there was no consensus in relation to the pensions interest in that matter. So I just want to check now whether the manner in which we are married, it's having the effect on the issue of the pensions interest, despite the fact that there was no settled agreement which was entered to. Yes.
Okay.
So I just want to check.
Okay, if there is no settlement agreement and the divorce order says division of the joint estate, the worst division of the joint estate automatically includes 50% of your pension interest. So as a non-member spouse, you are entitled and you have a share of 50% up until the date of divorce. Now the challenge will, okay.
Okay, so it is pointless now if we are in a community of property to venture to a settlement agreement with your spouse, because automatically there's, if in a case where there's going to be a divisions in terms of the assets, the court will always say that the 50, because of the virtue of the marriage that you've consented to in terms of the marriage with your spouse.
No,
so it's pointless.
It is very important to enter into a settlement agreement. Remember, the settlement agreement is going to state in detail how the joint estate is going to be divided. So the word division of the joint estate says the parties are going to share the joint estate equally. But now the question is, let's take we are now going into the house, we go to the kitchen. Yes, we have got a divorce order which says we have to share everything equal. How are we going to divide? How are we going to share equally? Because some things we can't just take a knife or take a saw and divide them into two. So in the settlement agreement, you will agree that everything we are going to share it equally. But you are going to be specific that, okay, you will take the corner sofa, I will take this one, you will take this, I will take this one. With the debts, you're going to specify all the debts and you're going to say, okay, on this S-gas debt, we're going to be 50% liable for it. Every month, you will deposit 50 rand, I will deposit 50 rand, we'll take this 100 rand and we're going to pay at gas. When it comes to the pension interest, the clause must have a specific wording. So if the divorce order simply says division of the joint estate, the non-member spouse will not be able to withdraw the amount. The pension administrators are going to send the non-member spouse a letter informing him that you need to go back to court. You need to amend the court order so that it specifically orders us to make to give you 50% of the pension fund. And how does it do it? By having this specific clause that must be in the court order. And in the court order, it says, let's say, for example, the defendant is entitled to 50% of the plaintiff's pension interest in the government employees pension fund membership number 123, and the amount has to be paid within 60 days of the order, or as regarding the time period. And this must be endorsed by the pension fund. So this is the specific clause that is needed before the non-member spouse can be given a share of the pension. So this is what I want students to do. If you get a chance, just go to your nearest magistrate court, the regional court. Go to the divorce section and request a copy of the free summons. Now the regional court, they issue out the free pleadings. Just request a copy of the free divorce summons and then just peruse it. You will see this clause that I'm talking about. So if the parties do not have a settlement agreement, the summons must at least have that clause, so that should it happen that the defendant does not dispute and does not defend the divorce, and the divorce is granted on a default judgment, the divorce order will have this specific clause that automatically will make it easy for the non-member spouse to be paid by the pension administrator.
Thank you, ma'am.
Okay, thank you. Okay, now last we are going to hear from Nicolas and Christian. I'm sorry that we ran out of time, but please you can send me an email because I'm having problems with the chat. The chat is saying I'm unable to send any message or to respond to any of you. My email address is monarkn@unisa.ac.za. Nicodemus. Okay. Christian Becky.
Yeah. Yes, ma'am. This is Christian. Yeah. Yes. I just want to find out if someone is it's getting divorced for the second time. What happened into the pension interest?
Okay, can you please repeat that again? You say when a person is divorcing?
Yeah, for the second time, ma'am, what happened to his pension interest? Let's say now he's getting divorced for the second time now.
They're going to share 50% of the withdrawn amount. So let's say the first time the non-member spouse had $1,500,000 was given to the non-member spouse, and now they are divorcing for the second time. For the second time, the 500,000 is the one where the 50% is going to be withdrawn from, so that they're only going to be left with 250,000, and their spouse, their non-member spouse, will get 250,000 rands.
Okay, ma'am. Thank you.
Okay, student, thank you for joining today's session. I'm sorry to have to cut you because I have another session starting now at 11:30. Please, if you need to talk to me, feel free to send me an email. Please note that.
Maybe, ma'am, before you go, I'm going to proceed with this class because I think this chapter is very lengthy, so we are going to start another new chapter when we are going meeting again.
Okay, we can quickly refresh because the next session is going to be about forfeiture of benefits. We can quickly refresh and then continue with forfeiture of benefits.
Okay, not a problem.
Okay, please note that all the recordings, the links to the recordings have been uploaded on my UNISA under additional resources, and also a summary of notes have been uploaded there as well. I will also upload notes for today's session.
Ma'am, can you please just repeat your email address before you go?
Okay, please check it on the. I think somebody has just said it, written it on the chat session, but it is monarkn@unisa.ac.za.
Okay, thank you very much.
Okay.
Ma'am, can I have some clarity before you go?
Okay.
I wanted to ask if two families get into a lobola negotiation and one family pay lobola for the other, and these two people will be considered to be married or not?
Okay, we will talk about customary marriage when we talk about customary marriage, but spouses who enter into a valid customary marriage are automatically married in community of property, and they will be entitled to pension interest during a divorce. They are entitled, or they have the right to also enter into a settlement agreement. What you must know about customary marriage is, firstly, the parties enter into a valid customary marriage if only lobola was paid were there also other requirements that were followed and that were fulfilled in terms of the recognitions of Customary Marriages Act? Yeah, but we'll talk about this in detail when we cover customary marriages. Students, thank you for joining today's session, and we shall meet during the next session. Have a good day ahead. Thank you.
Thank you, ma'am.
Thank you, ma'am.
Bye.
Thank you, ma'am.